Hello, good afternoon. Buonasera. I'm sure you like to hear more words from me. I have counted the words today. How many have been spoken? What do you think? 2,400,671. So I will add some 300 words to it, and then I'm finished. And that's the reason why Giuseppe De Palo placed the forum with some women at the end, because he expects us to talk less and to say the same. So I'm not sure if I will be able to do that. I have been a judge for 25 years, and in the first time I was a judge, I was very keen on legal problems. I liked them a lot. I still like them. But I'm not sure that if I give a judgment, I bring always peace into the room. So, when I was a vice president at the Court of Appeal, then, well, at length, I began thinking about bringing peace into the room, and how could you do that otherwise? So, then I have been trained as a mediator, and, well, it was a coincidence that 6 years ago I was appointed as the national project leader of a court-annexed mediation program in the Netherlands. We have done now this program for 6 years, and together with my colleague Madeleine Split, who is sitting here also, we have been rather successful with the help of lots of mediators and judges and lawyers. And now the Minister of Justice has promulgated a law, so to say, and January next we will implement a referral system in our court system for all the courts in the Netherlands. So we are working a lot on that now. And I am pleased to be able to tell you some data. We have monitored all our mediations. We have now about 2,500 mediations done, and we have, from all the mediations we have in our database, we have the data. So we have numbers about how many mediations, about success rate, about client satisfaction, about the motives for choosing for mediation, the motives of the judge, the motives of the parties, the motives of the lawyers. So we know a lot. And I cannot tell you everything in those 5 minutes I'm allowed to speak. So if you are very interested, just send an email. Giuseppe will help to find me. And we can give you more numbers. And in your materials are some articles, but we have new ones. So if you are interested, I hope you will find us. So these are very interesting success indicators. One of the biggest success indicator is if the party is really willing to negotiate. And then we have found out that if the party says in choosing mediation, I want to do mediation because it's quick, I want really to have my own decision and not a legal decision because the judgment cannot solve all my problems. If parties say that, then the success rate is more than 90%. Even in very complicated civil and administrative cases. On the other hand, if the conflict has escalated too much, then the success rate becomes very low. And if there is no room for negotiation, for instance, like Jeffrey Sanger said, in administrative cases, not always there is room for negotiation. So if that's the case, then it's not very good idea to go into mediation. But on the other hand, I have to say, in tax cases we have a lot of success, and it's not about diminishing the amount of tax to be paid, but parties often do not understand what they are talking about, or they have a dispute with the employee of the tax office. And so if there is some clarification of the problem, then the citizen is willing to pay the tax. So mediation is helping there a lot. And the success rate in the tax cases was about 86%. Then we have success rates, and perhaps you find them rather low, because we have started in 2001 with 52%, and now we are on 67%. But I have to tell you that in the Netherlands we have a system of settlement by the judge. So lots of cases are settled by the judge very early in the litigation. So if that's the case, we are not referring to mediation. So the cases that are referred to mediation are the more complicated cases in which the judge is not able to settle in a session. So if you know this, perhaps you can evaluate more this number. And we are very satisfied with the number, and so that's also the reason we will continue. And then I have to add something else, like Henrik Nielsen. What's the motive of the judges and the parties to go into mediation? We have found there is a lot of resistance with the lawyers, the judges, the parties, if you tell them it's an alternative to litigation. So we do not speak anymore about alternative. We are speaking about effective dispute resolution, and then effective can be judgment by the judge, settlement before the judge, mediation, an expert, or something like that. So we try to make a kind of a range of possible effective dispute resolution methods. So we try to forget the word alternative because that raises a lot of resistance. Some other data. Average civil mediation lasts 6 hours and some 10 minutes. Administrative cases are much quicker if it are small cases, so they have about 2.5 hours. Tax cases are even quicker, about 1.5 hours. And perhaps I must tell also that we are very keen on promoting facilitative mediation and not evaluative, because our judges are very well capable to make evaluative settlements. So if we offer mediation, we want it to be real mediation. And then the parties are involved, not the lawyers speaking all the time, but it's the parties' process. So the lawyers are, of course, welcome to be in mediation, but we try to make the parties' process. And that's working rather well. And we have, let's have a look. And then we have also measured the client satisfaction, and that is about, we have client satisfaction about the mediation and the mediator. And about the mediation, it's about, on a scale from 1 to 5, it's about 3.8 versus 4. And about the mediator, it's even higher, even if the mediation doesn't succeed. And then we have asked if the parties will choose a new for mediation in a new case, and also the lawyers. And if the mediations had a success, then 80% of the lawyers and the parties told us they would choose in the future again for mediation. Then is a very interesting finding that in 60% of the cases the mediation didn't succeed. The parties and the lawyers said directly after the mediation they would choose again. But then we asked it again after 3 or 4 months or half a year. And then what do you think? Is it lower or higher? Higher. It's 80% again. So directly after the mediation, people think, well, it didn't succeed, I don't know. But then they are going to trial again, and one is going to lose, and one is going to win, and then all of a sudden 8% says we are going to choose mediation in the future. So that's interesting.